August 26, 1982. Lawyers for the Johns-Manville Corporation walk into federal bankruptcy court in New York and file for Chapter 11 protection. This is a company with roughly $2 billion in annual sales, a fixture of the Fortune 500, the largest asbestos company in American history. The bankruptcy judge would come to describe it as the most financially healthy company ever to file for Chapter 11.
Healthy companies don't declare bankruptcy. What was on the books?
The books were clean. What wasn't on the books, 16,000 pending lawsuits, asbestosis, lung cancer, mesothelioma. And the company's own projections said the 16,000 were only the beginning.
So what do you call a solvent company that declares bankruptcy?
The company called it prudent planning. The plaintiffs called it something else. The court spent 6 years deciding who was right.
Prudent planning. Let's translate that. A company runs the numbers on 50 years of dead workers, sees the bill coming, and gets to the courthouse first. That's not planning. That's a getaway with better lawyers. Today on Asbestos, a conspiracy 4,500 years in the making.
Episode 36, The Johns-Manville Bankruptcy.
The healthiest bankruptcy in American history. Asbestos, a conspiracy 4,500 years in the making, is brought to you by Danziger and Dayano, the team families call when the company responsible no longer exists. dandell.com. That's DANDELL.com.
Last episode, Boral v. Fiberboard. The Fifth Circuit's decision in 1973 established that manufacturers had a duty to warn, and the floodgates opened. Then in 1977, the Simpson Papers surfaced, 6,000 pages proving the industry had known since the 1930s. Put those two things together, and every case against Johns-Manville got stronger. By the summer of 1982, the company faced 16,000 pending lawsuits, with hundreds of new filings arriving every month.
But they've been losing since Boral. That's 9 years of verdicts. Why quit in August of 1982? What changed?
Two things. Juries had started adding punitive damages, not just compensation for the dying, punishment for the knowing. And the company commissioned a study of its own future. The projection that came back, tens of thousands of additional claims over the coming decades, with an estimated price tag of roughly $2 billion. The liability was the size of the company.
Their own consultants told them the bill for 50 years of silence was everything, the whole company.
And the response to that projection was not a compensation program. It was a filing strategy.
Walk me through Chapter 11. What does it actually do? And hold on to one number while you explain it. 6 years. We're going to come back to what 6 years actually cost.
Chapter 11 is reorganization, not liquidation. The company keeps operating, the plants run, the paychecks clear, management stays in the building. And the moment the petition is filed, something called the automatic stay takes effect. Every lawsuit against the company stops immediately, nationwide.
16,000 dying plaintiffs, and every courthouse door in the country locks at once.
Think about what that means in practice. Somewhere in America that August, there's a plaintiff mid-trial, jury seated, testimony underway, maybe a verdict days out. The petition hits the docket in New York, and that trial just stops. The judge loses jurisdiction. The jury goes home. Not postponed a week, frozen with no date attached.
So the automatic stay isn't a technicality, it's a switch. One filing in one courtroom in New York reaches into every other courtroom in the country and shuts them all off at the instant.
That's exactly what it's designed to do. The stay is meant to give an honest company breathing room to reorganize, to stop a run on the assets while everyone sorts out who gets paid. It's a reasonable tool. Manville pointed it at 16,000 people who were running out of time.
A pause button built on balance sheets, pressed down on people with months to live.
For 6 years. And here's the number I promised you. The petition was filed in 1982. The reorganization plan wasn't confirmed until 1986. The trust it created didn't start paying claims until 1988. Now here's the part that gets me. Mesothelioma patients measure survival in months. 6 Years. Do that arithmetic.
How many of the 16,000 lived to see a payment?
Nobody kept that number, which tells you something by itself. We know individual stories, plaintiffs who died waiting, families who buried a claimant and inherited a lawsuit. The system that could calculate its future liability to the dollar never counted how many of its claimants were still alive.
Because that number wasn't useful to the strategy. Future liability tells you what to reserve against. Who's still alive tells you who you're making wait. One of those is a business input. The other is a conscience, and they didn't need it. Working inside this system after the Manville settlement, Danziger and Dayano developed a different approach, a way to file claims simultaneously against all the trusts qualifying families are entitled to. It's the way compensation can come in months, not years, when a family needs it most. Dandel.com.
Here's what 6 years in bankruptcy court produced. The reorganization created something that had never existed in American law. The Manville Personal Injury Settlement Trust, funded with $2.5 billion, cash, insurance settlements, and most of the company's own stock. Victims would no longer sue Johns-Manville. They would file claims with the trust.
And the corporation itself, what happened to the right to sue them?
Channeled, that's the legal term. A court injunction routed every asbestos claim, current and future, away from the company and into the trust. Manville walked out of bankruptcy in 1988, operating, profitable, and legally untouchable on asbestos. Victims stopped being plaintiffs in front of a jury and became claimants, filling out a form.
Say more about future, because that's the word doing the heavy lifting.
It is. The injunction didn't just cover the 16,000 who'd already sued. It covered people who hadn't been diagnosed yet, hadn't felt a symptom. Some of them were children in 1988. The court reached forward in time and settled the claims of people who didn't know they'd been injured before they knew.
A company negotiated away the right to sue it with plaintiffs who literally could not be in the room. Nobody represented them because nobody could name them yet.
And that was the innovation. That's why every asbestos defendant after Manville wanted the same deal, not just resolve today's lawsuits, buy permanent peace from everyone the product would ever hurt in a single proceeding for a fixed price set in advance.
Let me lay this out. This is the company whose general counsel put the word conceal in a 1941 memo, the company running the hush-hush policy while its workers' x-rays went undiscussed, the company Sumner Simpson told, in writing, the less said about asbestos, the better off we are.
The same company.
The less said. 50 years of the less said, and when the bill finally arrived, they found the one courtroom where the first thing that happens is everything goes quiet.
That's the part that stays with you. The strategy never changed. Silence as policy from 1935 to 1988. They just kept upgrading the machinery.
And the trust? What has it actually paid out?
More than $5 billion since 1988. It is still open. It is still paying. It became the template, the model every asbestos bankruptcy after it would follow. If someone worked with Manville products anywhere in the country, their family can still file a claim today.
More than 40 years after the filing and the trust is still processing the damage, that's not a safety net. That's a measurement of how long the harm lasts. One more thing about bankruptcy court. Rod Dayano started his career on the other side of it, at Jones Day, defending corporations in product liability cases. He was good at it, good enough to know exactly how companies protect themselves and exactly what that protection costs the people on the other side of the paperwork. So he walked away. He co-founded Danziger and Dayano in 1995, and he spent the 30 years since helping families collect what the paperwork was designed to keep from them, over $1 billion recovered. He calls leaving defense work the best decision of his career. If your family is facing a mesothelioma diagnosis, you want someone who knows how the shield was built and how to get around it fast. He built the firm to file every claim at once, so families can see money in months, not years. Call Danziger and Dayano, Dandel.com, Dandell.com.
Paul Danziger and Rod Dayano founded the firm in 1995. Nearly $2 billion recovered, over 1,000 families. Cases in all 50 states.
The consultation is free 7 days a week. Dandel.com.
You've been listening to Asbestos, a conspiracy 4,500 years in the making. Episode 36, The Johns-Manville Bankruptcy.
Research, writing, and production for this series is supported by Danziger & Dayano, a national mesothelioma law firm with over 30 years of experience and nearly $2 billion recovered for victims and their families.
Next time, the template spreads. Manville's trust was the first. More than 60 asbestos trusts followed, a parallel compensation system that today holds roughly $30 billion. And the question that system was built to avoid answering out loud: what percentage of a claim actually gets paid?
Pennies on the dollar. That's episode 37.
Episode 37, The Trust Fund System, on Asbestos, a conspiracy 4,500 years in the making.
16,000 plaintiffs, 6 years, $5 billion in counting, and the company walked out the front door, still open for business.
They filed the most honest paperwork of their lives. And it was a bankruptcy petition.
40 years later, the trust is still writing checks. So is the harm. We'll see you next time.
Thanks for staying with us. Stick around. We're still mic'd up. The thing I keep snagging on. Somewhere in that law firm, an associate drafted the petition, stayed late, got every comma right, probably kept a copy for the office wall.
Framed it, probably. You don't bill those hours to free 16,000 cancer patients and not hang the receipt. Best work of his career, and he can never tell anyone what it did.
And on the other end, it's a letter. That's how a dying man finds out. The case he was staying alive for stayed.
Dear valued plaintiff, justice is experiencing higher than normal call volume.
6 years of that. Same plants running, same paychecks clearing, same letterhead.
It's faking your own death, except you keep the house, the job, and the mail. Schrodinger's Corporation. Legally dead, commercially thriving.
That is genuinely not a bad description of Chapter 11.
I know. That's the terrifying part.
Here's what I couldn't say in the documentary voice. We've done 3 episodes on this company's paperwork. The Simpson letters, the conceal memo, hush hush. 50 years of documents. All of them lies. The bankruptcy petition might be the only honest thing they ever filed.
Because you can lie to workers, to doctors, to juries, to Congress. You cannot lie to your own actuary.
16,000 plaintiffs and the company's own accountants finally in agreement.
They ran the numbers on everything except telling the truth. Turns out honesty was the cheaper product. Never made it to market.